Matter is People versus Rhonda and Moser. File number is 2688FY. Ms. Moser is here with us by Zoom from the jail. Her lawyer, Mr. Tim George, is here with us. Ms. Moser, can you hear me?
Yes, I can.
All right. I saw this when you got arrested and was disappointed. You're charged with possession of methamphetamine as a drug double and operating while intoxicated as a third offense. Operating while intoxicated as a third offense is a felony punishable by up to 5 years in prison and 6 points and a fine of up to $5,000 and the suspension of your license. Your charge is a second habitual offender, which makes that punishable by up to 7.5 years in prison, and the drug double would make it up to 30 years in prison. So it's not good. I'm here with your lawyer, Mr. Tim George, and Chief Assistant Prosecuting Attorney Joshua Robert. Mr. George indicates you're going to waive the preliminary examination, have the matter bound over to circuit court, and excuse me, and but he wants to address your bond. Is that correct, Mr. George?
That's correct, Your Honor. We have, my client executed the written waiver yesterday at the jail. I provided that to the prosecutor. The offer in this case would contemplate a plea to the OWI charge and a reduction of the possession charge to a use and dismissal of the habitual offender notice. My client indicates that she's not currently on probation or parole. I think one of the big concerns that she has is she is currently doing online schooling through the University of Phoenix. If she remains in custody and is not able to get a hold of individuals at that school, I think she's concerned that she's going to lose the ability to continue on with that. The magistrate set the bond amount in $50,000 cash or surety. That's clearly an amount that my client is not able to meet. We would ask the court to consider whether a 10% provision would be appropriate in this case. I did talk to my client about the likelihood that if she were to be released on some type of bond, that she would have to comply with pretrial services. She indicates that she's amenable to that. That could include testing, tether, whatever the court would believe would be appropriate under the circumstances. So we would just ask the court for that consideration. And just so your honor knows, she did provide me an updated address that's different than what's on the complaint. So I can provide that to the court as well. Thank you.
The address we had was Kalamazoo. Where are you staying, Miss Moser?
Oxbow Drive.
All right. With who?
Wendy, WP Bontrager. It's my daughter's husband's mother.
With your daughter's mother?
Husband's mother.
Oh. All right. This is charged as a third offense, drinking, driving charge. This is a rollover accident with a 0.196 blood alcohol level, also methamphetamine. And they had trouble getting you out of the car. You were not in good shape. Your license is also suspended. You also have $536 worth of unpaid fines and costs. previous driving suspended from 21. I reminded you about it in November of 2025, disobeying a traffic control device and a speeding ticket. Mr. O'Bear, what's your position regarding the defendant's bond?
So I think this is a case where we do have to worry about the safety of the public. She has 3 prior OWI convictions, 2 in Michigan, 1 in Indiana.
So this is her fourth OUIL?
Yep, the one in Indiana was in 2021. That's the most recent. In that case, she was also charged with and convicted of methamphetamine. So it looks like she has 2 problems, methamphetamine and alcohol in both of these cases. And despite the convictions in 2021 and whatever sentence was imposed, she's continued with both of those habits. So we worry about her getting out and the danger she posed to the community. So we would ask the court to leave bond where it's at.
Mr. Gibson, do you have input on this?
Is the bond, what is the current bond?
Well, this is.
No, this is Mr. George's client.
Oh, okay, I'm sorry.
Yeah, you don't have it, you don't need
Is
to.
there another one that we need to do?
No, we're on to felonies.
Okay.
Um, At one time, all of the OUIL thirds were just automatically set at $50,000. Can't really do that anymore. But this one, the magistrate felt it was an issue of public safety. She does have a bad driving record. It is her 4th drunk driving conviction. This was a rollover accident. She was suspended. She pled to a driving suspended in front of Judge Pattison on January 21st from November. Apparently he just took care of that. I think she failed to appear. Let me look at that. She got a ticket on July 6th of 2024. She failed to appear in January. No, you can sit, Rhonda. You had that driving suspended from 2004. You'd failed to appear on several different occasions. You didn't deal with it until after you got arrested. So you had an open warrant for your arrest at the time you were arrested. Your license is suspended. It's a 4th drinking driving conviction with a rollover accident, a high blood alcohol level, and also a 2nd or subsequent possession of methamphetamine. You also have $536 worth of previous unpaid fines and costs. So the motion to reduce the bond is denied. You're not working, you're sleeping on your daughter's mother-in-law's couch, and you got some vague college tuition thing, but that doesn't outweigh the public safety issue. So the matter will be bound over to circuit court. If it's going to be worked out as a plea, perhaps sooner rather than later, you're going to get credit for all the time you're served, but I'm not going to reduce the bond. All right. I'll do an order.
Sir, I only have 56 credits to get my Bachelor of Psychology. So I've been going to college.
That's good.
It's not
Well, you
like I
had to show
just,
up for court, you had an open warrant for your arrest, and you're out rolling your car over with a 0.19 blood alcohol level. There's a consequence. All right, Jordan, I got Pablo in the waiting room. I'm not sure what to do with him.
We can proceed with a plea for that case, Your Honor.
All right.